Welcome to Shaping Canada, 150 Years of Landmark Decisions. The Canada we know today wasn't built by chance. Argument by argument, judgment by judgment, it was forged by law within a unique justice system born from the union of the civil law and common law and increasingly Indigenous legal traditions. In this series, we mark the Supreme Court of Canada's 150th anniversary by decoding some rulings that defined our rights, our freedoms, and our collective identity. From criminal law to Indigenous rights and the division of powers, the decisions we chose to share with you are not just ancient history, they still shape our reality today. I am your host, Hugo Martin, and I ask you to join me for exclusive conversations with the 9 justices of the Supreme Court and leading constitutional experts as we uncover the context, the impact, and the lasting legacy of these judgments.
Is the right to life also the right to choose how we die? To help us explore this powerful question, we're joined by Professor Jocelyn Downie. A university research professor at Dalhousie University, she was appointed a member of the Order of Canada in 2018 for her leading contributions to Canadian health law, particularly regarding medical assistance in dying and women's health. We discussed the landmark 2015 decision of Carter, a ruling that shaped the right to die with dignity in our country. For years, the criminal code banned assisted suicide. That ban was upheld by the Supreme Court back in 1993 in the well-known Rodriguez case, a narrow 5-4 decision where the majority prioritized the protection of vulnerable people over individual autonomy. But more than 20 years later, Kay Carter and Gloria Taylor, both living with devastating and incurable conditions, challenged the ban once again. They argued that the law forced them into a cruel dilemma: end their lives prematurely while they were still physically able, or endure a prolonged and painful death. The Supreme Court now faced a profound question: should it overturn its own precedent and recognize access to medical assistance in dying? That's the conversation we're diving into today. I am Laurence Lapierre, and I hope you'll enjoy this episode on a very important and current subject.
Professor Jocelyn Downie, thank you so much for being with me for this episode of Shaping Canada, 150 Years of Landmark Decision, and welcome.
Thank you. I'm very happy to be here.
We're going to talk about medical assistance in dying. And before getting into our landmark decision, I'd like to know the lay of the land. What was happening in Canada prior to the legalization of medical assistance in dying?
So I'd actually take us back a little bit before Rodriguez, because there were debates in Canada about withholding and withdrawal of life-sustaining treatment before we got into MAID. Because for a period of time, people probably aren't even aware, because it's so accepted now, that for a period of time, people couldn't even get refusals of treatment respected necessarily. And so there had to be litigation about that first. And that was the Nancy B case in Quebec, which made it clear that people get to refuse treatment that they don't want, even where the consequence could be death. So we had that debate, then that got resolved. And then we moved on to the MAID debate, and that took us into Rodriguez. We need to sort of see that there was legal activity, but there was also public discussion and public opinion. And the public opinion from very early on was very supportive of MAID.
Sue Rodriguez was an important decision. However, it was far from being unanimous. It was a 5-4 decision, and the dissent were really important. Justice Sapinka, who wrote for the majority, also had strong beliefs that medical assistance in dying could become a slippery slope, and he was really into the protection of the vulnerable.
I would note that it was speculation on his part, as opposed to evidence. And so there was a fear of the slippery slope, but there wasn't evidence to support that concern. Yet it drove the decision, as you say. They also were concerned about the lack of agreement with MAID amongst the medical associations in Canada and in the world. They felt there was a lack of public consensus, although I think that was belied by the evidence about public opinion, which was supportive of MAID. But you're right that I think the biggest thing driving the majority decision was a concern about a slippery slope of vulnerable people being forced to have made when they didn't want it, and so on. So that was driving the decision at the time.
The gist of the case was Article 241B, which prohibited assisted suicide. So that was basically what it was. So assisted suicide, we all know what it is. So ask a doctor or a friend or a close person to help you, aid you in dying. And that was illegal. So that was the law that was attacked based on the Canadian Charter. Sue Rodriguez was a 1993 case, so 11 years after the Charter. So there was never any challenges prior to this, Professor Downie?
There were attempts to change the law. There were bills introduced in Parliament. There were some court challenges. They didn't get very far. When it's a private member's bill, historically, they never got very far, and that's what these were. They weren't government bills, but there were multiple attempts to change it. And there were a couple of early lower level attempts, but they didn't get anywhere in court either. There were also a whole series of cases in which individuals were charged under the provisions that were ultimately challenged. So Section 241, as you say, the aiding suicide, but also Section 14. I mean, it's homicide, euthanasia, technically homicide. So there were a number of instances in which people were charged, but nobody was ever being convicted of murder or aiding suicide. They could have pleas to lesser charges. They would have suspended sentences for whatever they were convicted of, which was a lesser charge. And so there was this weird disconnect between the criminal code, which seemed, it was very clear, it's illegal. It's illegal in the strongest of possible ways, because when you take murder, that carries with it the life sentence. And yet nobody, even though we knew these cases were happening, and the police and the prosecution services knew they were happening, nobody was going to jail. So there was a disconnect. There were two disconnects, really. So there was a disconnect between the public opinion and the criminal code, and between the implementation of the criminal code. So you had this very serious offense or offenses, but nobody was going to jail. So what was going on there? And those cases kept going after Rodriguez, because the Rodriguez decision, as you said, was 5-4, and it didn't decriminalize assisted dying.
When you talk about other cases, we think about Morgenthaler for sure. But you're telling us also that there was, factually speaking, there was a lot of cases of assisted suicide, correct?
Assisted suicide or euthanasia, those actions could be charged under the criminal code. Yeah, there were cases, and nobody was going to jail. The only real case where people did was the Latimer case, but that is a case of non-voluntary euthanasia, and that is not legal now either. So it's, you know, we need to park that one, because it's very different from what people were trying to legalize and what became legal. That is non-voluntary euthanasia that was not, is not, and I don't think ever will be legal in Canada. And he did go to jail. But everybody who actually did the things that would technically fall under aiding suicide or homicide, where it was a voluntary euthanasia case, no, they weren't facing the consequences that were in the criminal code, in part because the public support for that was not there. And so when you look at the exercise of prosecutorial discretion, which has to factor in, is this in the public interest to pursue? That, I think, was influencing the outcomes of those cases.
And these attacks, let's say, on 241, the changing of the society's thinking about assisted suicide, it was driven by Article 15, equality right, and Article 7, life and liberty. We will talk about this a little later. But what was the approach? What was the attack angle that they were taking?
So legally, the attack angle was the Charter, Section 7, Section 15, and saying these are breaches of both of these rights, and they're not justified in a free and democratic society. When you take a step back behind the law, what is pushing the cases and what was pushing the public support for the cases would be respect for autonomy. So a recognition that this is a decision of fundamental significance to individuals, suffering, an awareness that there are a number of people who in the dying process will suffer intolerably in a way that cannot be remediated in a way that they feel comfortable with, and then a concern about protecting the vulnerable. Those three were together driving a move to legalize but one that would be wrapped in protections for the vulnerable.
So the dissent was based on both 7 and 15. Justice McClellan, who based herself on Article 7, and we have Chief Justice Lamère, who based himself on Article 15. But I think it's very important at this particular stage to talk about the dissent, because that will lead us to our landmark decision. And our landmark decision, we understand, is going to be from the Supreme Court of British Columbia with Justice Smith. But let's talk about the dissent in Rodriguez.
We see a 5-4 decision, which was probably the closest 5-4 decision ever. We never get behind the closed doors, but to see which way it could have gone. But it was a very stark split that was reflected in parliamentary committee discussions, special reports, all kinds of things as well. They were not out there in an unexpected way being split. And as you say, we did have decisions that focused on the equality aspect of it. So you have Sue Rodriguez, who is a woman with ALS, a degenerative neurological condition, which was going to put her in a place of being physically disabled such that she could not end her own life by suicide, but wanting to end the suffering because it would be intolerable to her. So people framed it up in terms of equality. So it's to not allow her to have that is discrimination on the basis of physical disability. And then some framed it up in terms of Section 7, as you say, because it is a decision of fundamental personal significance. There are echoes of the Morgenthaler analysis, right? When you have a decision of profound personal significance, it is a decision that should be able to be made by the individual. She wanted to make that decision. She fought for it. And I think they were paying particular attention and understanding the role of autonomy, her capacity, which was unquestionable, her decision-making capacity, the suffering, because they understood what ALS means. It is not a nice way to die, and focused on that. They were very much looking at Sue Rodriguez as a person, the individual who is facing that capture, which is effectively by the disease, and inability to escape from the disease. And they were not persuaded by what persuaded the majority in terms of this notion of a slippery slope and the active-passive distinction and concerns about medical associations and so on. They weren't persuaded by those, and so felt that this was a fundamental breach and couldn't be justified. And you could have a system that safely allowed some people to have access. And to not do so is to restrict choice in a way that we cannot do under the Charter, and was to discriminate on the basis of disability.
I think the first time you read Section 7, which the title is Life, Liberty, and Security of the Person, but when you read the actual provision, very, very short. Everyone has the right to life, liberty, and security of the person, and the right not to be deprived thereof, except in accordance with the principle of fundamental justice. Everyone has the right to life. The first time you read this, or when people hear this episodes right now, we're going to have somebody that's going to say, well, you have the right to life. Does that mean you have the right to end your life?
So in the Carter decision, it's very explicit on this point. And I think it did surprise a lot of people that they said denying access to MAID is a violation of the right to life, because we tend to think of the right to life as continuation of life. But the argument is this, that people will die earlier than they otherwise would when MAID is not allowed. Because what you do is you foresee getting into a state of physical inability to end your life by suicide. And so you end your life by suicide sooner. And so it's a violation of the right to life in that way.
Let's move to Carter, which is our landmark decision. But let's talk about Justice Smith first. Justice Smith was sitting judge from trial. There was other plaintiffs, Alice Johnson, there was Dr. William Shollet, the British Columbia Civil Liberties Association, and also Gloria Taylor. They decided to take another swing at 241B. And Justice Smith, in a 323-page decision, fully analyzed this matter and decided that basically society is ripe and there's enough difference in the Carter case from the Sue Rodriguez case to evolve and to challenge the Supreme Court's decision in Rodriguez. Now, it's a concept that it could be foreign to some of our listeners because we haven't talked about this before, but there's a rule called the stare decisis. The stare decisis is kind of saying, any court that's below the Supreme Court should follow what the Supreme Court said. Justice Smith was very well aware of this rule of the stare decisis. She decided to render a different decision, but at the same time, it was explained in a very detailed decision. And I'd like you to talk to us about Justice Smith's decision.
Sure. So one first quick thing about stare decisis. So Justice Smith is a judge alone at the trial level. Then there's the Court of Appeal, and then it goes to the Supreme Court of Canada. And I raise this because, in fact, she makes a decision. She explains all about stare decisis and so on, takes it into account, and we'll come back to that in a moment. The Court of Appeal actually overturned her decision, but it's actually illustrative of your drawing everybody's attention to the stare decisis point, because the Court of Appeal actually overturned her. We do tend to forget that or ignore it. It goes away because on stare decisis grounds, they're like, nope, the Supreme Court of Canada has ruled on this. And then it goes up to the Supreme Court of Canada, and then they actually accept that she was entirely right to take on the case. So she argues, well, it was argued to her, and she's persuaded that actually stare decisis should not stop her from acting, not just sort of saying, I'm bound by Rodriguez. Supreme Court already ruled on this. Sorry, go away. What she was convinced by was the evidence that A, the facts on the ground had changed dramatically, and B, the law had changed dramatically. And so stare decisis says, yes, you're bound by the higher court all the way up, but there are times when you are not bound by it. And these are the times. If the facts on the ground have changed enough, if the law has somehow changed, you are now allowed to consider the issue anew. And what she saw was that the evidence about what was known about slippery slopes, for instance. So, we talked earlier about the majority in Rodriguez being worried about slippery slopes. Well, the evidence of decades now was available to show that the slippery slope was a mirage. It doesn't happen. The fact that the medical associations had changed their views. The Canadian Medical Associations, by the time you get to Carter, they were neutral on it. So all of that evidence was now available. And then the law had also changed because between Rodriguez and Carter, you have the development of the principles of fundamental justice, Section 7, and it's critical, right? It's two parts. It's the rights, life, liberty, security of the person, but also not to be deprived except in accordance with the principles of fundamental justice. In Rodriguez, there was no principle of overbreadth, gross disproportionality. In Carter, those are the principles upon which the plaintiffs hung their case and upon which Justice Smith made her decision to say, nope, the prohibition does not violate Section 7. And so overbreadth and gross disproportionality came about as the Supreme Court heard different cases. These are not made cases, but other kinds of cases, and they introduced these principles. And so once those principles had been introduced and the facts and the evidence was available, it was time to relitigate Carter. And that's why Justice Smith was able to avoid the principle of stare decisis. She didn't have her hands tied by that because the world had changed. And when the world changes enough, the court system comes along with it. It has to come along with it. We have to recognize that a decision made decades ago could be wrong. It could be no longer valid. And when the facts change, when the law changes, that's the time to say, let's look at this again. And so she did. And when you did that, did you get it right? And they said unanimously, as strongly as they could, because they signed it, the court, capital T, capital C, which is sort of putting an exclamation mark on the unanimity of it. They said, you absolutely got this right. It's such a validating decision from the Supreme Court that Justice Smith should have felt very, very proud when she read the decision, because they recognized the rigor of her trial decision. They recognized and respected and took comfort in the voluminous evidence that was presented. So the evidentiary foundation was extremely strong. The judge's ability to critically analyze the evidence that was presented to her was very strong. And then her legal analysis was spot on. So I think the Supreme Court was then able to say, we really can rely. Not only did they affirm her ultimate decision of striking down the prohibition, but they felt that they had a very strong foundation in the facts. I mean, they never displace a trial judge on facts, but you can feel more and less comfortable. And she laid it all out. You emphasized how long the decision is. There's a reason for that. There was so much evidence, and she needed to explain why she was finding certain pieces compelling and others not. And I think also it served a really important public function for the legitimacy of law. When you're making such a monumental decision, to have the facts laid out so clearly, what's the evidence upon which I am making this decision? I think that really helps the public understand why was that decision made and take comfort in the rigor of the analysis of the facts, and also be comforted by the very facts that are out in the world about there isn't a slippery slope. We have decades of experience in places and the slippery slope is not there. The public can read it and say, oh, okay, I understand how she got from the facts to this decision, to this monumental decision. And then the Supreme Court picks it up and is able to feel confidence in the facts. And they do their own legal analysis, obviously, but they do find that she got it right. The decision's short because they don't have to take issue with all kinds of things that were in her decision at all. It's a foundation, it's a blueprint for their decision.
We will obviously put a link to Justice Smith's decision in the episode notes. And you are right. The evidence section is so broad. So we talk about the current state of the law, the practice in Canada. She talks to ethics professionals, practitioners, obviously professional bodies, medical bodies, public committee, public opinion, prosecution policies. You did say before, so the way prosecution was applying 241B. She also admitted and required evidence from other jurisdictions. We're talking about Oregon, Washington at the time, Belgium, Switzerland, Luxembourg, Montana, Colombia, the impact of ethics part on the medical part. It's absolutely a feat of analysis, and we're just talking about evidence at this particular point. And now Section 7 says everyone has the right to life, liberty, and security of the person. It doesn't say life is before liberty, and it doesn't say that liberty is before security. So when you look at the analysis, it makes a lot of sense from the Supreme Court that says not one is more important, and liberty means that it's fundamental personal choices. So that would be the first application of Section 7 that they decided to do. There's no order. It's a little different than when we read Section 7, when we think, everyone has the right to life. End of sentence. No. It's life, liberty, and security. And tell me if I'm wrong, but this is one of the ways that we can read this decision.
Yeah, I think it was in a sense easier for them, and they wouldn't have to parse them because all three drive you toward allowing MAID, right? Mm-hmm. So you analyze the right to life because it's this notion of I have to die earlier than I otherwise would want to if I can't have access to MAID. Liberty, security of the person, about fundamental decision making. It all comes together. And so you don't need to prioritize anything because nothing's in competition and they are all driving in the same direction.
There's a test after this based on Article 1 of the Charter. So tell us a little bit why it wasn't saved, basically. Article 241B was not saved by Article 1, which is the Oakes test.
Inside Section 1, it's two parts, right? Do we have a breach of the right to life, liberty, security of the person? Yes, check. But was it in accordance with the principles of fundamental justice? Because if it's not in accordance with that, you don't even get to Section 1. And if you do, then it's a breach of Section 7. Now, when you go over to Section 1, one of the elements of the Oakes test is minimal impairment, which means, did you limit the right as little as possible, as little as you had to in order to achieve the objectives of it? So the Section 1 analysis that they do is it prescribed by law? Yep, it's written in the criminal code. Is it demonstrably justified in a free and democratic society? And that's when we get into the Oakes test. Is it? And the key element of the test is, so you have to say, is it rationally connected? Yes. But is it minimally impairing? No. And that's where the evidence comes in to match up with the law or to inform the analysis of the legal situation. Because what all these other jurisdictions show is that you can carefully circumscribe access to MAID and still protect the vulnerable from dying by suicide in moments of weakness, is the language that's frequently used. They show that you can. You don't have to have a blanket ban in order to protect people. You can have a permissive circle. And so you have your carefully circumscribed sphere within which people can have access to MAID. And if you can do that and still protect the vulnerable, then your law is not demonstrably justified in a free and democratic society. And that's the basis of this decision at its heart. The most fundamental aspect of it is to say, no, you can have a carefully defined regime that allows MAID for some and protects the very people that you're wanting to protect.
So now we need rules and regulations. We say 241B is unconstitutional. So that means that the day after, right away, everybody can get medical aid in dying. So it's an audio podcast, but you're making big no's with your head. So it's a no. First thing that the Supreme Court did is okay, so this is our decision, but it does not go into effect right now. Again, we are seeing that our Supreme Court is very much in tune with the Canadian society, saying, now let's take a break. We need to set out some rules, some regulation, a way of doing this. And how does that work, Professor Downie?
So it's called a suspension of a declaration of invalidity. And what they do, and it's not unheard of, is they say when they strike down a law, if they recognize that there may be time needed for implementation of systems to deal with the now legal activity, whatever it might be, they say exactly what you said, which is, okay, we are striking it down, but we're suspending the effect of our declaration of invalidity for X amount of time. And they did that initially for 12 months. It ended up being extended for 4 more months because there was an election and the government wasn't ready. So they give the government time. It is important because people often misstate this. They say they do it because the government had to legislate. In fact, the government didn't have to legislate. They could have waited for the 12 months and done nothing, and then the law would have been gone and MAID would have been a health service. And that's what they did with Morgentaler. The abortion law struck down. The federal government never introduced, they never passed legislation that would provide that sort of regulatory framework for abortion. So abortion is just regulated just as any other health service in Canada at the provincial territorial level. So the government did not have to, but they chose to. And so they were given this 12 and then 16 months within which to figure out how they wanted to, what eligibility criteria, what procedural safeguards, and to give also not just the federal government, but the provinces and territories time to put in place systems, navigation systems for patients, education of clinicians. This was a brand new practice. And then the Declaration of Invalidity took effect. And then the federal legislation was in place to regulate the practice.
Let's go post-Carter. They did not have the obligation to legislate. However, they said, let's make some kind of criterias. Why did the government decide to legislate? Why did the government decide to make rules?
I think they wanted it to be delivered in a careful, circumscribed way. They wanted to give guidance to clinicians so that they would know what they could and couldn't do. They wanted the public to have trust in the system and not think it was just a free-for-all. So I think they put that in. They also narrowed it. So I'm not sure that was intentional, but that's what happened. The other aspects of it are things like the procedural safeguards, and that's to have a well-regulated regime for this practice. And so they put in place the federal legislation, knowing that there would need to be a lot more done at the provincial territorial level because, of course, this is health. And health is provincial largely. And so you were going to have provinces and territories establish systems
You've published a paper titled From Prohibition to Permission, The Winding Road of Medical Assistance in Dying in Canada. The narrative is divided in three phases. The Rodriguez era, which would be the prohibition. The Carter era would be the establishing of the right. And the legislative era, which is the parliamentary response. And that led us to a case called Truchon, because C-14 was a bill that went a little over what the Supreme Court had taught us in Carter. You've written about this. Let's talk about C-14. So after Carter, the Parliament of Canada passed Bill C-14, which, like I said, and like you argued, that it was more restrictive than the Supreme Court of Canada's decision.
So the Supreme Court of Canada said, we're striking this down insofar as it doesn't allow access for people who have a grievous and irremediable medical condition causing enduring and intolerable suffering that cannot be relieved in circumstances they find acceptable. Then what the federal parliament did is it took grievous and irremediable medical condition and it put a definition in C-14. And that definition narrowed the eligibility because it said you have to have a serious and incurable illness, disease, or disability. Okay. Be in an advanced state of irreversible decline in capability. Still okay with Carter. Be experiencing enduring and intolerable suffering that can't be relieved by means acceptable in circumstances again. And then it said natural death has to have become reasonably foreseeable. That was the moment when I read that, I fell off my chair. What on earth does this mean? Because I remember saying in a technical briefing before the public release of it, like they do it an hour before kind of thing, I said, my natural death is reasonably foreseeable. Everybody's is certain. So I asked that question. Obviously, the answer back was, no, we don't mean that. So we mean there's enough proximity to death. The course of your life has changed because of a new diagnosis. We now know the path you are on to your natural death. That they tried to explain it. One thing we pointed out was when they first offered an explanation was like, Kate Carter would not have qualified. Kate Carter's death was easily 10 years out. Kate Carter had spinal stenosis, degenerative, true, but on actuarial tables, she could have lived another 10 years. So it was this peculiar, like they started first with saying, well, you're close to death, you're dying. Well, Kate Carter wasn't. So they suddenly had to pivot because I think they didn't know that. And so they pivoted to it being enough that it could include Kate Carter, which required them to be into this notion of a predictable trajectory toward death. We knew how Kate Carter was going to die. It was just going to be quite a while. So they had to pivot on that. And, within 10 days of Bill C-14 being introduced, Joe Arvey, who was lead counsel in the Carter case, was back in court because it was unconstitutional. It was inconsistent with the charter. It was inconsistent with the Carter decision. Joe came in. I was there. We were arguing, this is inconsistent with Carter and charter, but they didn't agree, and so they passed the legislation. So immediately there was litigation. And that litigation, there was litigation in BC, and then subsequently there was litigation in Quebec. And that's the Truchon case, and that's the one that came to a decision ultimately. And so that was two people, both with disabilities, severe disabilities, saying this natural death reasonably foreseeable condition is inconsistent with Carter. You've narrowed Carter, which you can't do. It's a Supreme Court of Canada decision. And it breaches our rights under the charter, clearly. And so we had yet again a brilliant decision. The quality of the decision, just as in Carter, is exceptional. And we are very fortunate as Canadians that we have these two trial decisions with such care, thought, rigor put into them because they're making monumental changes in our law and they are solid. So whichever way the decision had gone, you can respect the decision. But we had that in Truchon. Again, the evidence was incredibly strong. Her thoughtful analysis of what was presented to her, the cross-examinations that revealed the weaknesses in the evidence about slippery slopes and so on. And so she went through all of that. And she analyzed the Carter decision to see how it applied to this. And she came out with a decision that the natural death has become reasonably foreseeable, had to be struck down.
The Parliament of Canada went back to the drawing board. They cut C14 in half, and they came up with C7, which removed the reasonably foreseeable natural event requirement, correct?
Right. And just as with the Supreme Court of Canada decision in Quarter, there was a suspension of the declaration of invalidity in Truchon. Again, they didn't have to legislate, but they chose to legislate. They chose to do C7. They did take out natural death is reasonably foreseeable. They actually made some other changes, some of which I think were very good. And one very significant one, I think, was very bad because, yet again, it was inconsistent with the Carter decision, and that's the exclusion of mental illness as a sole underlying medical condition.
Let's talk about Carter's impact, and I'm going to use your own words. The road from prohibition to permission for MAID in Canada has been long and winding. The journey is not over. There's a need in Canada for MAID. We are giving, I would say, humane medical attention to people that need it. What should we look for in the future? And what is Carter's legacy?
What we look for in the future is mental illness as a sole underlying condition. So picture a circle that's Carter, and it's the eligibility criteria. Then we introduce C14, and that circle shrinks. Then we have the Truchon decision, and the circle goes back out to the same boundaries as Carter. And then we have C7, which shrinks it again. So that's one thing to watch for. The other thing to watch for is a discussion of advance requests, because this was not dealt with in Carter. So for years, we've had in Canada an advance directive. What it is it's a way of saying, these are the decisions I am making now about my care in the future if I lose capacity, or these are who I want to make my decisions when I lose capacity. Those have been around for decades now. They are regulated at the provincial, territorial level. And I can say, if I am in a persistent vegetative state, I don't want any artificial nutrition, hydration, or if I get pneumonia, I don't want antibiotics, that kind of thing. That's well established in law. But you cannot ask for MAID through those instruments. MAID would not be permitted under the provincial territorial legislation about advance directives. Where advance requests come in is that is a request for MAID that is made in advance of loss of capacity. And at the moment, federally, that's illegal because you have to give express consent immediately prior to the provision of MAID. So you request it and you go through a whole process, but also right before the needle, you have to give express consent with a little exception that we don't have to go into right now. Except, and the big asterisk on that statement of federally illegal is legal Quebec. It is now legal and it is being implemented in Quebec because Quebec has its own MAID legislation. We haven't talked about that yet because we've been focused on Carter and the federal, but Quebec came along and introduced its own MAID legislation years ago. And then subsequently, what they did recently was they said, okay, now we are in a place where we're going to allow advance requests. So in advance of loss of capacity, decision-making capacity, I can say, if I have a diagnosis with a condition that will cause me to lose capacity, classic example that everybody's worried about is dementia, Alzheimer's disease. If I have that, I can say, when I get into such and such a state and I don't have decision-making capacity anymore, I'm consenting to MAID. And that's legal in Quebec, but the rest of the country can't have it. The vast majority of Canadians want it, but Quebec decided to do it. And Quebec has, interestingly, because of course the criminal code is federal, listeners might be thinking, wait a minute, it's illegal under the criminal code, legal under the Quebec health legislation. How can clinicians provide it? And initially, I would have said to any Quebec clinician, do not provide it, because it doesn't matter that Quebec has said you can. There's the criminal code, so you could get charged. But the Minister of Justice and the Director of Public Prosecutions in Quebec has stated explicitly, as long as clinicians follow the Quebec law, they will not be prosecuted under the criminal code. Mature minors, that was not in front of the court. It was about competent adults. A mature minor is an individual under the age of majority who nonetheless has the decision-making capacity of somebody who's 22, 55, whatever. They have full decision-making capacity. They're just under the age of majority, which is arbitrary. And they make healthcare decisions all the time. They can refuse life-sustaining treatment, for instance. So they can make life and death decisions, but they're not allowed to have MAID at the moment. So there will be litigation on that in the future. I'm sure of it. But it doesn't flow in the same way from Carter as mental illness and natural death reasonably foreseeable.
As Canadians, should we be proud of Carter?
Oh, indeed. There's so much to be proud of about Carter.
Are there any other jurisdictions across the world that talk about Carter, that apply those principles? Are there any laws or any rules that have been put in place in other jurisdictions, in other countries because of Carter?
There is such jealousy amongst colleagues around the world for us having Carter. Carter has been really important in other jurisdictions. They look to Canada, not just the Carter, but what flowed from Carter, to see a system that I think is working extremely well. And why should people be proud of Carter? I think it recognized the right to life, liberty, and security to the person. It recognized the right to make profound decisions of personal importance, and it gave that to us, all the while also making it very clear that we need to protect vulnerable persons. Absolutely not giving up on that. It also had a deep compassion in it. If you read the decision, I mean, the first paragraph is so strong with where it ends. A person in the circumstance of someone like Gloria Taylor is faced with this horrible decision to be whether they end their life by suicide sooner or they have a prolonged, protracted period of suffering that they don't want. And the language is, this choice is cruel. And that showed that the court was human. They understood what was at the heart of the decision, and that propelled them into the legal analysis that then affirmed what the human would say. We have this decision that was so thoughtful and careful, and it provided for the world, when you look at the trial decision, it provided an incredibly robust analysis of the evidence that was available from around the world. And that is useful to parliamentarians and courts around the world. It's also a model of a decision, I would say, in terms of how she used social science evidence. She had a philosopher in front of her, ethics evidence, the clinical evidence. All of that is really important in constitutional litigation. So beyond the MAID context, Carter's very important for constitutional litigation because it shows how to do it well around matters of social significance.
Incredible. You're absolutely right. And it's true that since 1982 or 1983, the first cases about the Charter, it evolved in the way we analyze the cases and how we should bring the evidence forth in order to get a decision. And like you said, it's at the trial level. So we didn't wait for the Supreme Court to do all this analysis. Justice Smith did it, and Justice Baudouin as well in Truchon did it. I'd like to go back paragraph 1 of the Carter decision from the Supreme Court of Canada. It is a crime in Canada to assist another person in ending their own life. As a result, people who are grievously and irremediably ill cannot seek a physician's assistance in dying and may be condemned to a life of severe and intolerable suffering. A person facing this prospect has two options. She can take her own life prematurely, often by violent or dangerous means, or she can suffer until she dies from natural causes. The choice is cruel. Paragraph 1.
It's so strong. And the humanity comes through in both the trial decision in Carter and the Truchon decision as well. But you can imagine if you've argued Carter and you've gone through the trial and the appeal and you're up to the Supreme Court and you're opening the decision. I was sitting at my dining room table. I had an iPad and a laptop and my phone, and it comes up and I read the first paragraph. That was a moment. That was such a profound moment because you knew at that moment where the decision was going to go. And you also knew they understand and they care, which matters for us in looking at our courts, I think, as Canadians.
Professor Jocelyn Downie, thank you so much for your insight, your generosity, and your humanity in explaining to us what Carter is, what Carter leaves us, and how it is a landmark decisions in Canada. Thank you so much, Professor Downie.
It's my pleasure. Thank you.
Thank you for joining us for this episode of Shaping Canada, 150 Years of Landmark Decisions. As we've explored today, the law is not static, it is living. Every Supreme Court ruling adds another stone to the foundation of our society. For links to the decisions discussed and more information about our guests, visit shaping-canada.ca and make sure to read the show notes. Subscribe on your favorite podcatcher so you don't miss any part of this series marking the 150th anniversary of the Supreme Court of Canada. Thank you to everyone who contributed to this project: the Supreme Court of Canada, the Right Honourable Richard Wagner, Chief Justice of Canada, the Honourables Nicolas Cazirère, Suzanne Côté, Andromache Karakatsanis, Sheila Martin, Malcolm Rowe, Mahmoud Jamal, Michel Obonzawin, and Mary Moreau, Professors Louise Langevin, Jocelyn Downie, Carrie Frock, Naomi Metallic, Karen Drake, Denis Nadeau, Félix Mathieu, Éric Labelle-Eastaff, Marcus Moore, Joel Backen, Howie Kislowitz, Richard Moon, and François Tanguay-Renaud. Thank you to Maître Michel Lebrun, Miss Sandrine Raymond, Laurence Laperrière, and Laurence Thériault, Mr. Peter Warren, and our producer, Constance Saint-Pierre. This project has been made possible by the Government of Canada. I am Hugo Martin. Until next time.